Pearl is also employed full-time and is not able to provide care during the work week. And we also have a temporary order in place right now. Um, so that order is the order that controls. Um, I just like to note, my client submitted this documentation to front of the court for the reimbursement. The fact that we're here arguing over $392 a month is, uh, I'm shocked that we're here arguing over this. Dr. Kroll makes probably at least 4 times as much as my client. I'll just go through, for example, a list of expenses for these children that my client has borne the sole responsibility for since the divorce. 100% of the nanny costs for childcare last summer, which she didn't seek reimbursement for. The GTAX tuition for the children for the 2021-22 school year in the amount of approximately $12,000 that Dr. Kroll refused to contribute to. School laptops for the kids, their cell phones and their cell phone plans, clothing, volleyball camp, which Dr. Kroll agreed to reimburse my client $80 for last summer and still has yet to reimburse her despite her sending numerous messages.
This section hits hard. Mom argues remote work isn't free time. She's juggling calls from 20,000 students and can't babysit at the same time. Courts everywhere struggle with this modern dilemma. Does working from home erase the need for childcare or make it more critical?
Phones and their cell phone plans, clothing, volleyball camp, which Dr. Kroll agreed to reimburse my client $80 for last summer and still has yet to reimburse her despite her sending numerous messages. Uninsured healthcare expenses. My client has paid 100% of the uninsured healthcare expenses for the children since the divorce because Dr. Kroll has refused to contribute, and she's submitted requests. He's demanded other itemized confirmation of payments, even though in the divorce judgment itself, it says that specifically plaintiff is not required to keep an accounting of expenditures for ordinary healthcare expenses. So this is a legitimate work-related childcare expense. There is nothing in the judgment or the deviation language that states that my client would bear the sole burden of childcare expenses. And in fact, she has been exercising significantly more overnights since the divorce judgment than was contemplated in the calculation when that judgment was originally entered. A good portion of that was based on Dr. Kroll's agreement. I understand there are other issues in dispute regarding the overnight time, but at least a period of that was by agreement. So she has really taken on the primary burden here of supporting these kids. Meanwhile, Dr. Kroll has recently purchased $1 million house. My client recently had to sell the marital home that she was awarded so that she can support these children and support, frankly, the cost of this litigation. So this is, I think, a reasonable request on her part that he contribute to the child care expenses. They are legitimate, they are work related, and she's only utilizing this nanny 3 days a week when in fact she could utilize, honestly, 5 days. And so we would request that that adjustment continue.
Ms. Emulus, how does Ms. Kroll's work from home schedule make her unavailable to provide care for the children at the same time?
I can go through a summary that my client just sent me this morning of her job description. I mean, I think we all understand work from home with kids, even, a 10 and a 12-year-old is extremely difficult. My client is on calls. She has things that she has to attend to, and she needs to be 100% focused on her job. So I guess just to summarize for the court, some bullet points on her roles and responsibilities with Blue Cross Blue Shield. She has a customer-facing role with several universities' HR leaders. She's responsible for handling student health plan, benefit, and plan inquiries, updating plan documents, and digital content. She's the primary point person for handling critical and urgent inquiries from nearly 20,000 students and HR leaders. Ms. Kroll was just in my office yesterday and trying to juggle an emergency call with a university or to deal with university health insurance policies while we were trying to participate in the settlement conference. And so it really is like when these crises come up, it's urgent and she has to be on it. And it's not something where she can just leave a call or it's.
Here's the bombshell. Dad's lawyer hints the upcoming custody evaluation could flip everything. If custody changes, today's fight over $392 a month may be meaningless. Smart lawyering or stalling tactic? That's the tension boiling right here. Interview. And finally, the judge slams the brakes, adjourned for a full evidentiary hearing. But here's the kicker. All current payments stay in place. For Mom, that means carrying the cost now. For Dad, it means buying time, betting the custody report will bail him out. The tug-of-war isn't over, it's just paused.